From February 6th, we looked at an article, we marked it up for evidence, reasoning, style, and we filled out a graphic organizer. Opinion: getting suspended or expelled should not be the end of hope. The story is familiar. A high school student grabs another student's iPhone at lunch and tries to sell it. He is caught, arrested, and booked into juvenile hall. He is also suspended from school. This would be an example of an anecdote or a story, so we can label that E for evidence. If universities and colleges follow the recent recommendation of the Obama administration, colleges will not consider the student's criminal record in the initial stages of the admissions process. There's a fact, more evidence. These recommendations, contained in a recently released letter by Education Secretary John B. King, Jr., represent a significant step in removing barriers to education for people with criminal records. This would be reasoning. That's when you explain evidence. Just this week, over a dozen colleges and universities signed on to the White House's Fair Chance Higher Education Pledge. More facts, more evidence. Primarily, this first paragraph had evidence, but there was a little bit of reasoning. Common college application question. Unfortunately, the letter and the pledge do not address another common question in college applications. Have you ever been suspended or expelled from school? This is an example of style. It's asking a personal address or a question directly to the reader. For the teenager who stole the phone, this means that while his criminal record may not ruin his chance to be admitted to college, his school disciplinary record just might. That's a fact, more evidence. More than 3 million students are suspended or expelled from school each year. That's a statistic, which is evidence. When this happens, a discipline record is generated. While the barriers created by criminal records have begun to receive much needed attention, the barriers created by school discipline records have been largely overlooked. More facts, evidence. The Department of Education report that accompanies King's letter mentions school records only in passing, without taking a firm position. Like criminal records, school discipline records can and do threaten young people's chances to succeed. Like criminal records, school records are a scarlet letter. So you could say this is reasoning because they're explaining the evidence, but I think even more so there's some style. They use repetition, like criminal records. They repeat that phrase. They also use the allusion, scarlet letter. It's referring to the novel by Hawthorne. The idea was that a woman who was an adulteress had to wear a badge that was the letter A, branding her as an adulteress. A fresh start. According to a study released last year by the Center for Community Alternatives, roughly 75% of colleges and universities collect high school discipline information. Almost 90% of those use the information in admissions decisions. The Common application, used by 600 colleges and universities, asks applicants if they have ever been found responsible for a disciplinary violation at school. School discipline records are not automatically expunged. So all of that was facts, and here's a little bit of reasoning. According to the study, 50% of high schools provide colleges with these records. More facts. The Obama administration's commitment, so I'm just going to label this E actually, before we go on. The Obama administration's commitment to giving people with criminal records a second chance should be extended to students with school disciplinary records. Students' mistakes in middle or high school should not cast a shadow over their future or prevent them from attending college. Indeed, most states limit public access to juvenile court records for precisely this reason. They share a belief in giving young people a fresh start when they become adults. This is all reasoning. They take that evidence, the evidence that was presented in the previous paragraph, and they explain it. They explain its relevance. You could also make the case that there's some style here. Can a mistake really cast a shadow? That's a bit of imagery there. No role for discipline records in college admissions. School discipline should play no role in college admission decisions for several reasons. First, these records have no predictive value. There is no evidence that criminal background checks reduce crime on college campuses. Everything we know about neuroscience and adolescent risk-taking establishes that children don't think like adults or have the ability to control impulses, and that children grow out of problematic behavior. So there's not a lot of actual facts or statistics listed here. There's some generalizations, perhaps, and some reasoning presented. You could say there's no evidence that criminal background checks reduce crime. That would be a fact. And children grow out of problematic behavior is probably an explanation of those facts or some reasoning. Second, research shows that Black and Latino students are punished more often and more harshly in school than white students who engage in the same behavior. This means that because of bias, over-policing, and profiling, Black and Latino college applicants are at a greater disadvantage than other applicants. So there's some reasoning. They're explaining why those facts are not fair. All groups are not treated equally. Third, school discipline records, like criminal records, are often inaccurate, misleading, or both. Talking back to a teacher may be labeled as defiance. Grabbing a cell phone at lunch may be classified as a robbery. And a schoolyard fight where a rock is thrown can be an assault with a deadly weapon. Students rarely have a lawyer and have few chances to challenge the claims in the first place. In contrast to the criminal justice system, where there are some very limited opportunities to have records cleared, there is rarely such an option for school records. The result? School discipline records that may be unreliable and misleading are a barrier to college admission. A lot of reasoning there, explaining, especially down here. School discipline records that may be unreliable and misleading are a barrier. Last section, chilling effect. Shouldn't colleges be aware of serious crimes like murder or assault? There may be strong policy reasons for schools to consider very serious criminal convictions in limited cases. This is an example of a counterclaim. The rest of the article keeps repeating how we should not use discipline records. But here they say an exception. The Department of Education letter would not eliminate the use of criminal records in all cases. However, the report rightly takes the position that even serious convictions on their own should not bar someone from higher education for all time. So there's where they shoot that down. They bring up the other side, and they say it shouldn't affect your ability to go to college forever. Even serious crime by young adults does not indicate adult criminal behavior. Applicants with criminal records have completed the punishment a judge or school deemed appropriate. There's no need to continue punishing them. More reasoning there. In any event, the logic of looking past a criminal history applies even more strongly to school disciplinary records. School records do not depend on the findings of a court. The school's burden of proof is lower, and the rights of the accused barely exist. In his letter, King emphasizes the chilling effect of asking college applicants about criminal records. The same chilling effect occurs with school discipline records. The message that box sends is, there is no outgrowing your childhood mistakes. So outgrowing mistakes, there's a bit of personification. And chilling effect, you could argue, is some vivid language. So some style there. What you would do then is, on this graphic organizer, we're going to fill out the main claim and some best examples of evidence, reasoning, and style. So the main claim is that school discipline records should not be used for college admissions. Some of the best evidence, well, we're going to look back wherever we saw an E, and we're going to try to identify which of these examples is most persuasive. For example, we could mention how 3 million students suspended every year. It's a pretty informative statistic. It's a widespread problem. Should all these people have their chances of going to college impacted? You could also use the other statistic they mentioned, how 90%, we're going to write it in the right box, 90% of colleges that use records use them in admissions. So if a college looks at your school records, they're going to use it as a factor of whether you should be accepted or not. And over here on the right, you're just going to write why those are strong claims. Affects lots of people. And limits opportunities. Some examples of reasoning. Well, we could bring up the counterclaim. Use records for murderers. And what this does is appeases the critics. If somebody is saying, you have to use records, it shows what a person is or how they will act. Well, it's true that if somebody commits a terrible crime like murder or assault, they may not be fit for your campus. Other types of reasoning, you could use that idea that school discipline records may be unreliable and misleading. And why is this relevant? Because it's unfair. As far as style goes, we could use the idea of scarlet letter, the allusion, and if somebody was familiar with the text or even the movie Easy A, they would understand what that is saying and what that means. With only a couple of words, you've said a lot. You can talk about outgrowing childhood mistakes. And there we go.